The law on adultery in India has come under scrutiny again. The Supreme Court has raised an unusual question. It asked why only men are punished under adultery law and not women. Here's a report. Early in the new year, the central government is expected to respond to the Supreme Court's question on a matter involving men and women. We are not talking of marriage here, but of adultery. What does the law say? Currently, the law holds that a man can be punished for adultery. But there's no punishment if the husband consents to another man having sex with his wife. In other words, the law appears to regard the woman as the man's property. The irony is as recent as 1988, when the Supreme Court said a man can be punished for adultery, but not the woman, and ruled that this was not gender discrimination. It seems the court is now ready to revisit its judgment of nearly 30 years. It'll be interesting to see what the government's response will be. Bureau Report, WION. And let's take our discussion forward. We're joined by a panel of experts here from New Delhi. We have Aishwarya Bharti, she's an advocate with the Supreme Court of India, and also Mr. Kaleeswaram Raj. He is also an advocate with the Supreme Court, and currently he was the petitioner on this particular issue. I welcome you both to the discussion. Let me begin by asking you, Mr. Kaleeswaram, do you think this decision to revisit the law and the fact that the re-examination of the offence of adultery is prima facie an admission that the court has consistently gone wrong in denying that this colonial penal provision that we see is actually, quote-unquote, male chauvinism disguised as a beneficial law for women?
Yes, in fact, it's an archaic law, as it is very evident. We know that the Indian Penal Code was enacted in the year 1860. It's a pre-constitutional statute. But apart from being archaic and even obsolete, we have contended that Section 497 is intrinsically arbitrary and even perverse. It negates the entire concept of civilization in an egalitarian society. It is gender discriminatory on three grounds. You will find that once it is conceptualized as a criminal offense, there is no reason or rather justification in putting only one sex into dock and exonerating other even by statute itself. Number two is a situation where the consent makes it a non-offense, or it is the lack of consent by the husband which makes it an offense, which essentially means a wife is just a commodity possessed by the husband. In that way, it is highly undemocratic and anti-gender and anti-woman. Thirdly, you will find that is again a very significant situation. Suppose the adulterer is having a wife, and that wife also is aggrieved by the offensive activity. And in that case, even that wife is precluded from prosecuting the woman who is involved in the very same activity, who is already exonerated by the statute. So it's a very, very kind of, a lot of ironies are there, lot of perversities are there, lot of irrationalities are there, right in the statute. And we know, we live in a country where the legislature doesn't take legislation seriously. Very often it requires the Constitutional Court to intervene in the matter and to review the statute. It is therefore, in my humble view, it's a positive gesture which the Supreme Court has shown yesterday, and a revisit not only to the statute, not only the statutory provision 497, but 198(2) of Criminal Procedure Code, which says that only the husband can file the complaint, not even an offended woman against the woman who is involved in the act of adultery can file a complaint. That again has been challenged. We expect that there will be some positive outcome when the matter is considered by a larger bench consisting at least 5 judges on the bench. Right.
Mr. Kaleeswaram, do stay with us. I also have Aishwarya Bharti. She is a senior lawyer at the Supreme Court. Aishwarya, this archaic law, let's call it the sort of Victorian law, so to say, or the provision, so to say, it's remained in the statute books for so long.
Yes, you're right, Jessica. This is at best And not just that, it remained in the statute book for so long. You know, our IPC, Indian Penal Code, was ultimately framed in a time when Macaulay, 1860, he did it. So it has stayed on for a very long time. But, you know, this provision was even challenged before the Supreme Court of India after independence, and it did not meet with the mandate of the Supreme Court. That's all I can say. They felt that this cannot be, this can either be made gender neutral nor be taken away from the statute book, and therefore this has met with judicial scrutiny before and failed of the Supreme Court of India. However, having said that, I think this provision is nothing but a blot which shows that it starts with treating women as an object of the men. So it is at best a relic of the patriarchal mindset, and it must be done away with. For gender justice and gender neutrality, it has to give way to completely sensitive issues. But I do want to raise one more issue. Mr. Kalvirajam raised the issue of the wife of the adulterer. So she has no remedy. It's double whammy. It's not just about making it gender neutral from the point of view of punishing the woman who is in the adulterous relationship. It also would be about providing a remedy to the wife of the adulterer who right now has no remedy. But I do want to raise a larger issue also, that the whole concept of having adultery as a criminal offence in the penal code itself needs to be revisited. Most countries have done away with it, and after all, these are consenting adults that we are talking about.
Absolutely.
And yes, having an extramarital affair, no doubt, is absolutely an offence to the matrimony, but it should remain an offence for the matrimony, and it should be a punishable cause for getting a divorce decree and other actions under the matrimonial law. Should it remain a penal law? Will it not have the same sanctity as Section 377, consenting adults, relationship between them being penalized under the penal law? So these are also questions that I hope Supreme Court considers. And every generation has to fill in the rights. Supreme Court has time and again said, even in the privacy judgment, that fundamental rights are like empty vessels. And every generation has to fill in the wisdom of their own generation into those vessels. So time has come. I'm very happy. I'm glad. I feel, honored that I'm part of the great institution which has chosen to take cognizance of it. But I hope all other issues are also considered in the right perspective.
You've raised some interesting points there, Aishwarya, and also the point on how the world looks at adultery laws. Stay with me, both of you. Let's look at what are the adultery laws in the world. South Korea has decriminalized adultery. It revoked a law that punished cheating spouses with up to 2 years imprisonment. South Korea was one of the only 3 Asian countries to still criminalize adultery, alongside Taiwan and the Philippines. All European nations have decriminalized adultery, and while it is not considered a criminal offence in most Western parts, it may still have a legal consequence, especially in divorce proceedings. Especially with Taiwan. Taiwan's adultery law are an anomaly in the region, with the offence punishable by up to a year in prison. The country's Minister of Culture, Lung Ying-tsai, had described the law as archaic, and interestingly, he called it embarrassing, according to the Asian Sentinel. Now, countries governed by Islamic law, including Saudi Arabia, Pakistan and Somalia, all strictly prohibit zina or fornication outside marriage. Prosecutions are common and punishments can include fines, arbitrary detention as well as imprisonment, flogging, and in extreme cases, even death penalty. Women are overwhelmingly targeted for adultery and remains illegal in 21 states across the United States. The law extends back to the Old Testament, where these women were treated as property. And Mr. Kaleeswaram, this particular provision, since the provision was enacted at a time when women were mere properties, how correct are the earlier judgments that upheld the provisions?
Yes, what has happened actually is, in fact, this provision has its roots in the Macaulay draft, and the major portion of the Macaulay draft we have incorporated as part of the pleadings before the Supreme Court. Lord Macaulay even collected so many opinions on this, and interestingly, even at that point of time, there were differences in opinion, and a prominent view was rather that this is to be treated just as a civil wrong and not as a penal offense. Nevertheless, it so happened that it happened to be incorporated in the Indian Penal Code, and strangely, thrice this was challenged before the Supreme Court. As my friend Ms. Aishwarya has rightly said, thrice it was challenged before the Supreme Court, and once again, interestingly, this was considered in 1954 by a constitution bench consisting of 4 judges, and their lordships said at that point of time that this protection given to the women as a class, as a category, is something in the form of a beneficial measure, which is rather unacceptable for any modern democracy, because you cannot visualize an exoneration with respect to criminal prosecution as a beneficial measure. This is a situation where 2 parties are involved who are having equal involvement. Then, when it was challenged in 1985 and 1988, again curiously, it was rather presumed that the women are incapable of committing the offense. These 2 views are something in common, and what is in common is something discouraging, something dispiriting, in the sense that both these views visualize women as slaves or as somebody subordinate to the male class. This is an attitudinal situation which requires a correction. A perceptual change is much due with respect to the adultery law and adultery jurisprudence. Therefore, I would say that by lapse of time, now a rethinking has been emerging, and even the Law Commission said, way back in 1971, the Law Commission report said that the offense as it is now framed is something which is very obsolete and which is very unreasonable, and it requires a revisit. At least after
absolutely, it requires a revisit, Mr. Kaleeswaram. Interestingly, there you pointed out it does require a revisit. And Aishwarya, if by any chance, let's not preempt or predict what's going to happen, if the court strikes down the adultery provision, so should the Parliament come up with a provision which is in fact gender neutral?
Jessica, I myself, I personally is of the opinion that the adultery provision is a completely absurd provision. Even while we used to study it as students of law, we used to be absolutely amazed with the constitution judgment that Kaleeswaram ji is talking about. The reasoning there is absolutely absurd, and the provisions of the law itself are very, very replete with the patriarchy. So it does not augur well with the 21st century India that we imagine, with the gender justice and gender neutrality that we talk about. But speaking for myself, I also think that criminal laws should not find too much space in marriages and matrimonies. I think marriages should be dealt with in the matrimonial sphere of the laws, and putting too many laws into the matrimony will be like introducing a bull into the china shop. That's how I feel. So I don't think it should be gender neutral, because it just look at the language of the law. It says that if without the permission of the husband, if somebody indulges into a sexual relationship with the wife, so if somebody is doing with the permission of the man, it's fine, and it is an offense against the husband, against the man in the marriage, and
right.
There is the woman is not to be treated as a better. And then what is the remedy available to the lady whose husband may be indulging in adultery? So
absolutely, that void also needs to be filled, Aishwarya. Completely agree with you there. New norms need to, new ways of revisiting this judgment as well. I'm sorry, Aishwarya, we had to cut you short there. We're running out of time. Thank you, both Aishwarya Bhati and Mr. Kaleeswaram, for joining us on the program this evening and discussing this.